All right, joining me to talk about that interview, once again, criminal defense attorneys Page Pate and Keith Lamar. The defendant in the interrogation, he doesn't seem to understand what they're trying to get at there when they're asking about the injuries. They want to know if he shows any significant injuries after this. I mean, you look at the crime scene. This was a brutal attack, and he really doesn't have any. How significant is that for the defense? Did it help either side?
Well, you have to take the whole thing in context, and I assume the jury's going to hear little bits and pieces as they go through the case, and he says some things that are obviously not true. He's going to be inconsistent with his later testimony at trial, but the ability of him to sit through that interview with that demeanor, talk about things, you're right, he's not thinking ahead. Obviously, he wouldn't have talked to the police to begin with if he was thinking ahead. I'm going to be a suspect in a death penalty case. I wouldn't do this. But to me, it does suggest that he's willing to do that because he's not trying to hide anything other than his affairs, his other potential problems he may have, but not that I just committed this horrible crime.
Threw his phone away. Why? Why did you throw your phone away?
Yeah,
Isn't that compelling? I mean, why would
No, it's not compelling.
Why would he throw his phone away?
You know, the prosecution, if they suggest this is the demeanor of a guilty person, they haven't seen the folks we've seen in interviews and interrogations who are actually guilty people. I mean, nervousness, sweating, unable to follow a simple narrative. This guy's sitting with investigators for how long? How long is he in this room talking about everything?
2 separate interviews.
Yeah, no, I don't see it that way. But then again, the jury doesn't come with that background. They haven't seen a lot of people.
They see a liar, someone who's concealing it. Why would I throw a phone away and then be vague about it and not have a reason for throwing a phone away? They're expensive. Right. So was he lying because he didn't want to get caught cheating on his wife for the umpteenth time? That, again...
That could be assumed.
Absolutely.
Yeah. And that's what you believe?
Yes. Because why does he think this second cell phone has anything to do with the death of his kids and this woman? I'm still not following that.
Well, because he told police I wasn't anywhere near her house. You could check my cell phone.
He's not playing three-dimensional chess. He's not thinking they're pinging my records and they've got me geolocated. No, that's not.
Why would he say check my cell phone? I was at home. If he didn't know that the reason a cell phone would put him at home. He knew that his cell phone put him at home. It was an alibi for him.
I just don't know if he's thinking that far ahead.
This is a fascinating case. It really has captured the attention of the country. This victim, I mean, you can't get any more innocent. This is a young mother with a 1-year-old child. She was a pilot, 29-year-old woman. The defense case is that the girlfriend who's now come up here on the stand and told you this story about how Patrick killed her with a baseball bat. Well, guess what? She's the one that did it. How did she know these details? She lied about everything for so long. Is that a viable defense? I guess it's the only one they have, but how effective can that be? On the other hand, you got a defendant that looks like a complete creep, and you just think, and you see the victim. How do you combat that as a defense attorney?
Well, you do what this one is doing, and you attack this particular witness. I mean, I'm sure Keith as well. I mean, we've tried a lot of cases where you have cooperating witnesses, co-defendants who've entered into pleas and then will testify for the state. And talking to juries after those trials, they usually take that testimony and they discard it. They say, look, they have a motive to lie, they've got some deal they're trying to work out. The question is, will this jury find that the other details about her testimony corroborate that and overcome that bias that she would otherwise have? Yeah, and the state's resting their entire case. I mean, they have this other evidence to try to corroborate it, but she is the star witness. And by putting her out there like that, you obviously give the defense a way to attack the case, and then the jury's left saying, either I believe her or I don't believe her. He's guilty or he's not guilty.
The details that she provided to this jury were so horrific that he brought her into, he went to her apartment or condo that she was living at, and he had a sweater with a baseball bat hidden in the sweater, and then tells her they're going to play guess the scent of the candle game. So close your eyes, honey, and puts this blindfold on her, which puts the sweater around her head, and then starts to beat her to death with a baseball bat. I don't care who's sitting at that defense table. Yeah. You're disgusted and you're sickening. Do you have to put him on? This is a case of there's not enough to convict my client.
Right. You just never know. I mean, I find it odd for a defense lawyer at the beginning of a trial, an opening statement saying my client is or is not going to testify. I think you got to watch the jury. Are they finding her credit? Are they listening and paying attention to her testimony? It's a judgment call. It's always a tough judgment call, but I think you make it at the end of the case.
How important is this witness to this case. And that last statement seems pretty clear.
I'm not even sure he needs to testify at this point. I mean, what we saw was a defense lawyer already getting that theory before the jury, before any witnesses even came to court. So if for some reason, and I can see many reasons, why Santos may not actually want to tell this story under oath with a judge, with a jury there, and he takes the Fifth Amendment again, you've already got the jury having heard what he said, having heard that he confessed to this crime, and then him hiding behind the Fifth Amendment, saying, I don't want to talk about it anymore. So even if he doesn't actually testify, his mere presence is a huge win for the defense.
If you watch any of these shows on Netflix, a big thing is you do not cross the cartel, no matter what. I mean, you just do not, because there is a price to pay. And isn't that the motive here, which Santos referred to in the letter? It's like keeping up this business and keeping it straight and letting you know that everybody along this chain is in fear for their life.
You know, it shouldn't come down to this, but unfortunately many times in a trial it does. Who has the better narrative? Does it make more sense that he killed this woman and his own child over $20,000? Or like Keith was saying, that this was a cartel hit? And yeah, cartel, they kill people. That does happen. It may not happen every day in Tallahassee, Florida, but it does happen. And so at the end of the day, the jury, especially if he comes to court and provides some testimony, I think that narrative makes more sense than the state's.
Way more sense.
One of the other things he said in the letters that he sent to Segura's attorney reads as follows: there is a hit on me, but the guy they sent is not a killer. Anyway, look, it will not be long before some fool kills me thinking I'm a rat. So I'm asking you all to fix this. I would rather be dead than be in protective custody. I refuse to do that. I welcome death, because when the death angel comes, I'll take one with me. Trust me on that. So he's a little bit off his rocker, right? I mean, he's writing letter after letter. He's got a little edge to him. Let's say you're the prosecutor, and Carlos comes into court. How do you handle him? Where do you attack him?
You know, how do you really attack him, right?
I'm waiting to hear.
I was like, how do you really attack him?
You're making this up. You're a loon. You're sitting in jail, and you're just here for fun.
But there's no motive. There's no good reason for him to do this.
Out of nowhere, just make this up. I mean,
because you're a fake gangster. Oh, Mr. Carlos Santos.
He's in federal prison right now for being a gangster.
Well, he's in federal prison, but he also threatened the DA in Fulton County, Georgia, and he threatened Charlie Crist, the governor of Florida. I mean, this guy's got a little baggage as he steps up to the stand.
What would you expect from anybody that's saying
a gangster?
He's letting you know that I run the cartel, or whatever his role is in the cartel, and he's letting you know. So what he's saying kind of fits the bill. I can see if he's coming there saying, I've never hurt anybody.
Well,
do they need to make that link between Brandy Peters and the cartel? Something that says, yes, she was involved.
I think that would certainly help, but I don't think they have to. Back to the original question, how should the prosecutor deal with this witness? It's not like he's simply going to come in there and tell the same story he has in the letters. There are procedures that the court has to follow in a situation like this. I've had a trial like this. A guy who is going to come in and potentially admit to a serious crime, he's going to be advised of his rights. And if you're the prosecutor, you want to make sure that the judge cautions him, make sure he talks to a lawyer. A lawyer can be appointed just to talk to him before the testimony, and maybe you chill it a bit. Maybe all of a sudden he becomes a reluctant witness. He's not the same guy writing these letters, and then the jury doesn't think as much of his story.
All right, Page Pate, Keith Lamar, thanks for hanging out this morning.
Thank you.
It was enjoyable, a lot of great discussion. When we come back.